terminally ill adults end-of-life bill. There's been 7 attempts to legalize assisted suicide before this. It's been debated in Parliament well over a dozen times. The bill defines terminal illness as a person having an inevitably progressive illness, disease, or medical condition. So it was medical condition, that's been scrapped. With this definition, it can include diabetes, hypothetically. It could include anorexia. And in committee, no less than 5 amendments on anorexia were tabled, and all 5 were rejected. So we have the Noel Conway case. He was given a life expectancy of 6 to 18 months. He lived an additional 7 years. So if he met a doctor who was sympathetic to his plight today, it's foreseeable that he would be able to obtain assisted suicide. Netherlands, 10,000 deaths from assisted suicide last year. That was like 5%. You have 20 newborn infants euthanized every year in the Netherlands. People for depression, people for any number of things. So I like to quip that the only thing we want to assist to die is this bill. It's a pleasure to be with you all today to discuss this very serious subject, and we'll jump right into it. So the terminally ill adults end-of-life bill, as Tim was saying, the bill was introduced by Kim Leadbeater. It was first really put into the public sphere at the second reading on the 29th of November. It was a private member's bill. In the bill, pursuant to Section 24 of the proposed bill, Section 2 of the Suicide Act 1961 would be repealed, decriminalizing suicide when performed under the remit of the bill. The proposed law would also remove any form of civil liability for ending one's life unnaturally within the terms set in the bill, and perhaps equally worrying, Sections 24 and 25 make further allowance for courts to find no liability either criminally or civilly for instances of assisted suicide that are occasioned in instances that aren't in the bill. So that is kind of an extraordinary measure to say, here's how we're doing it, but in other circumstances, courts do not have to find civil liability or criminal liability. So it's quite a remarkable thing that a lot of people aren't talking about. One of the things that changed from last week is now the Welsh Senate will now be voting on whether to opt into the bill or not. So that in itself is a victory. Tim was telling me that not too long ago they had a vote in Wales and they voted it down. So that's helpful. The third reading, as Tim was saying, end of April, and the vote may be then or certainly by mid-May. So as Andrea was saying, there's been a number of attempts to legislate this issue, and part of what I'll be doing here today is I'll be talking about the earlier legislative attempts and the strategic litigation that got us to where we are, and then the other side of the issue, which is really the type of, I wouldn't even say it's passive euthanasia, it's this de facto euthanasia that occurs through our courts, the Court of Protection and the High Court, which was found through the Bland case and its progeny. So if you go to 2014, when the Supreme Court was discussing the Nicholson case, they go through a chronology really of what happened in the 9 years previous. So from 2005, and that was Lord Joffe's bill called the Assisted Dying for the Terminally Ill Bill, which was, I believe, the first time the issue was introduced in the United Kingdom. Then you had in 2009 Lord Faulkner introducing an amendment to the Coroners and Justice Act of 2009, trying to decriminalize assisted suicide through that means, and that failed. In September 2010, you had the Faulkner report. So you had perhaps one of the biggest campaigners in the Lords for this issue, who was commissioned to do a report on assisted dying. The funding largely came from campaigners and proponents of assisted suicide, so it wasn't surprising when it came out and then pushed the position forward that assisted suicide needed to be legislated in the UK. Post-Nicholson, You had three private members' bills. In June 2014, Lord Faulkner, after his report, came back and introduced a bill that was debated in Parliament for 10 hours. It was further debated in committee. Parliament was prorogued, and it didn't get a vote on it. However, 1 year later, in June 2015, Rob Morris, the Member of Parliament, introduced the Assisted Dying number 2 bill into the House of Commons. It was essentially exactly the same bill that Lord Faulkner had put, and it was resoundingly defeated. It was defeated 118 in favor and 330 against. On the 9th of June 2016, Lord Hayward, a Conservative MP, so this was the first time the Conservatives had introduced a private member's bill into the House of Lords, but this one didn't even get past the first reading. Then we had the Conway case, which we'll talk about in the next slide. They do a similar exercise as the Supreme Court did in Nicholson, and they talk about the bills that had come forth. January 2020, you had yet another Lord Faulkner bill that reached second reading. May 2021, Baroness Meacher introduced another assisted dying bill. That didn't make it past the first reading in the House of Lords. And that takes us to 2024, where Kim Leadbeater has done what none of her predecessors have been able to do, and that is to get it to the finish line and potentially over. So I like to quip that the only thing we want to assist to die is this bill. But essentially, the previous bills, there's been 7 attempts at bills to legalize assisted suicide before this. It's been debated in Parliament well over a dozen times, so it's quite a remarkable thing. I can't think of anything else in our legislative history that has been so actively pursued by Parliament so doggedly. And that has included strategic litigation, a lot of strategic litigation, which has gone hand in hand with the legislative efforts. And I mean, just from a strategic campaigning perspective, as much as I disagree with the issue, it is quite remarkable to see how coordinated this effort was, because in the next slide we'll talk about the DPP and how that adds another element to it. But the first case that came before the courts, it was in 2001, 2002, and that was Pretty v. UK. So that made it all the way up to the House of Lords and eventually to the European Court of Human Rights. So Diane Pretty, when she was 43, she reached out to the DPP, the Director of Public Prosecutions. Someone wrote a letter on her behalf. She was suffering from motor neuron disease, which is a progressive neurodegenerative disease, which breaks down, it weakens the voluntary muscles, and death eventually comes when those voluntary muscles no longer allow you to breathe. That's the typical way of passing along with that disease. And she wanted her husband to assist her to die, and she was seeking really from the DPP an assurance that he wouldn't be prosecuted. In August 2001, the DPP refused the request, and the case was judicially reviewed, again, eventually making its way to the House of Lords. So for those who aren't lawyers, up until 2005, when you had the Constitutional Reform Act, the House of Lords was the highest court of appeal in the United Kingdom. After that, it's been the Supreme Court. And the Supreme Court is distinct from the courts of England and Wales. It is the Supreme Court for the entire UK. It was accepted, so 2001, this is 3 years after the passing of the Human Rights Act. So you had the European Convention of Human Rights already transposed into the domestic law. So it was common between the parties. The common law did not allow for assisted suicide. So the question was whether there was incompatibility with the convention, whether Section 2 of the Suicide Act was incompatible with the convention. The Lords held, and I would say rightly so, that they are not a legislature. And they went through, again, the previous efforts, saying this has been discussed by Parliament umpteen times. They are the ones who hear the evidence, debate this, do public consultations. That's how a law should be passed. and they punted on it, saying this is a matter for Parliament, essentially. It went up on appeal to the European Court of Human Rights, and there again, the Pretties lost. And in that case, it was an interesting judgment in the sense that so Article 2 of the Convention is the right to life. And one of the articles that the applicants were seeking to pin their case on, oddly, was Article 2. They were seeking the right to die. And the court said, look, we can't read the right to life article as conferring a right to die, basically. So that part of the application was shut pretty quickly. However, Article 8, so through the convention, Articles 8 through 11 are so-called qualified rights, meaning they're not absolute rights. They can be qualified under certain conditions. The first is that it has to be prescribed by law, meaning that the law has to have sufficient clarity for someone to foresee their actions, and it has to be something that is written down, not necessarily written down. Even an employment contract is deemed to be prescribed by law, and Richard O'Dare would know that because he, yeah. The second is that it serves a legitimate aim, and the legitimate aims are all enumerated in the second clauses of those articles. They're like national security, health and safety, things like that. So that one is almost always deemed to be, as long as it's something that's in the convention, then that's almost an automatic green light on that one. The third prong is typically the one where they get stuck, and that's the proportionality assessment. That's the action has to be necessary in a democratic society, meaning that to achieve that legitimate aim, the interference has to be proportionate. And there's different balancing tests for that. So what happened in the Pretty case is they said, look, issues of how you live your life, even how you want to die, are covered by Article 8 of the Convention. That's the right to privacy. I mean, it's actually quite an encompassing right. It's not just data privacy, but home privacy, the right to self-actualization. So even things like transgender identity, drag queens, things like that are covered under Article 8. So they interestingly won on that issue. So that was a departure from the House of Lords, saying that, okay, Article 8 is engaged here, but that's only the beginning of the story in a sense, because it is qualified. And what the court said at paragraph 74 of its judgment in rejecting the application of the Pretties was Section 2 of the Suicide Act is designed to safeguard life by protecting the weak and vulnerable, and especially those who are not in a condition to take informed decisions against acts intended to end life or to assist in ending life. The court also said that many terminally ill individuals will be vulnerable by definition, and it is this vulnerability of that class which provides the rationale for Article 2. And so the Article 2 was upheld as being within the margin of appreciation of the UK. And margin of appreciation is essentially the folks in Strasbourg. And it's a beautiful town if you've ever been to Strasbourg, but it is so dislocated from the reality of the rest of Europe. There's no direct flights even from Brussels, believe it or not, or from Vienna, where I usually take my flights. It's hard to get there. Those judges live in a bubble. And so their feeling is, look, we're not going to step into the shoes of the domestic authorities unless we have to. So we're going to create this margin of appreciation doctrine, which gives a certain discretion to the member states in how they legislate. And in this case, that was basically, for this issue, we're going to give the member states a wide margin of appreciation, which was wonderful for this case, not so wonderful if we challenge the Leadbeater bill on incompatibility grounds. So this leads us now to our Purdy v. Director of Public Prosecutions. It was a judicial review by Debbie Purdy and her family. Now she suffered from primary progressive multiple sclerosis. So unlike the first case, she had wanted to go to Switzerland where it was legal to have your life ended, and she wanted her husband to accompany her. She had asked the DPP to provide guidance on whether her husband would be prosecuted. It refused to do so. And the Lords, when the case made its way up to the Lords, and they had said, departing from the Pretty case, we now accept that Article 8 is engaged, but like the ECHR and like the previous judgment, we're not a legislature. This is an issue that's being debated currently in Parliament, as it seems to always be debated by Parliament at one point or another. And so we're going to leave it to Parliament. But the DPP guidance is not prescribed by law. So that first prong saying the law must be foreseeable. It has to be something where a person needs to be able to judge their actions accordingly. And I would think that was a highly political move, because there's all sorts of criminal laws where there's not guidance on whether you can break it a little or a lot. Nevertheless, within 3 months, the DPP had draft guidance out for consultation, which was eventually adopted. They had a number of factors which spoke towards probable prosecution. Things like if the person was under the age of 18, if they were coerced, if it was active persuasion of someone, if the illness wasn't terminal, things like that. And there were 6 factors where they said we will be less likely to prosecute. So the first was the victim had reached a voluntary, clear, settled, and informed decision to commit suicide. The suspect, that's the person assisting, was wholly motivated by compassion and nothing else. The third, the actions of the suspect, although sufficient to come within the definition of the offense, were of only minor encouragement or assistance. Number 4, the suspect has sought to dissuade the victim from taking the course of action which resulted in his or her suicide. Now these are just factors. You don't have to have all of the factors in order to not be prosecuted, but these are the factors they were looking at. Number 5, the actions of the suspect may be characterized as reluctant encouragement or assistance in the face of determined wish on the part of the victim to commit suicide. And number 6, the suspect reported the victim's suicide to the police and fully cooperated with the investigation at all times. So that was kind of the first cannonball hitting the ephesus of Section 2 of the Suicide Act. Then we have the Nicholson case, which took place in 2014. So Tony Nicholson, in 2005, he suffered a severe stroke, which he was paralyzed from the waist down. And his case was different than the previous 2 cases because he wanted to die by way of doctor-assisted suicide, and he wanted to do it in the UK. So he didn't want a spouse to assist, and he didn't want to go to another jurisdiction. He relied solely on the Human Rights Act, and he essentially wrote the DPP saying, this is what I want. I want assurance that the doctor won't be prosecuted. He didn't get that assurance, and he judicially reviewed the case. A second and unrelated appeal was joined, and that was someone who sought an amendment to the DPP, from the DPP to their guidance on going abroad and getting assisted suicide, whether the person aiding and abetting that trip to Switzerland or wherever it might be would get prosecuted. So they were joined. It went up to the Supreme Court, and by a majority of only 5-4. So now we have a very slim majority. The court followed the reasoning in Pretty and the progeny, saying we're not the legislature. This is discussed over and over. Section 2 serves a legitimate aim, so on and so forth. And on the issue of the cross appeal, they said, look, now we have guidance that's finely tuned. You can't ask for better guidance, essentially, from the DPP. So we're also denying the appeal. And so that case was lost. Nevertheless, the DPP, again in 2014, shortly after this case, decided to change its guidance. And I believe that the DPP director at the time is the current prime minister. I could be wrong about that. Yeah. And essentially they were doing what this gentleman wanted to do on cross appeal, saying doctors will likely not get prosecuted if they perform assisted suicide under certain conditions. So Christian Concern, through these 2 individuals, Nikki and Merv Kenward, who are disability campaigners, judicially reviewed the guidance, saying, look, this is, now you've essentially legalized, in some sense, assisted suicide, because you're decriminalizing it in a very significant way. Now, Nikki, shortly after her marriage to Merv, had suffered from a serious virus, and basically she was locked into herself for a period. So she was in a coma, but she was aware of the world outside her, and so she realized that under the current regime that she was a prime person who might be victimized by the existing laws, which were, shifting towards assisted suicide and more nefariously euthanasia. Unfortunately, that case was lost, and the court said that it was within the margin of discretion afforded the DPP in making their guidance. And last but not least, we have the Noel Conway case in 2017. That's the last time it came before the courts in any significant way. So Noel, like Diane Priddy, suffered from motor neuron disease. He was diagnosed in 2012, so this is 5 years on. What makes his case interesting is that he was given a life expectancy of 6 to 18 months, which, as I'll discuss later, the prognosis for the Leadbeater bill is 6 months. So if he met a doctor who was sympathetic to his plight today, or perhaps in 2029, when this potentially rolls into action, it's foreseeable that he would be able to obtain assisted suicide. He lived an additional 7 years to the ripe old age of 71, and he did not die of old age. He shut down his ventilator and passed away that way. So it just shows that prognoses are not particularly accurate when it comes to end-of-life issues. So he essentially followed the lines of Licklinson, and the High Court said, we've been down this road quite recently. The only difference now is that at that period of time there was no bill before Parliament, but it was almost inevitable, and certainly right afterwards there was more bills to come. So his case was ultimately rejected. He won grounds. He was granted a right of appeal, lost on appeal, and then was rejected at the Supreme Court level. So that's the history of the case law leading up to where we are. And now I want to kind of divert into the other side of this issue, and that's euthanasia. And I think it's right to call it euthanasia that's happening post-Bland. So the two big cases I want to talk about here, the first is Airedale NHS Trust v. Bland, 1993. So people with my accent remember the Terry Schiavo case in America, and there was the French case as well, but this preceded all of them. And this was a young man who was a big Liverpool FC fan and was part of the Hillsborough Crush. That was the soccer match, the football match, where 94 people died as a result of just fans being let in and crushing. It was during the FA Cup in 1989. 94 people died that day, hundreds injured. One person died within 3 days after. Tony lived another 3 years in a permanent vegetative state. So his brain cell was functioning, so it controlled his breathing, his digestion. So he was alive in a very real sense, but there was no meaningful chance of recovery according to the doctors. His family, working with the hospital, petitioned the court saying that we want to basically end his treatment, knowing that it'll end his life. And so this was kind of the case that you hear about, and I'll be talking about some of them, the Alfie Evans cases, the Sadiksha case. This was the grandfather of that case, where the court said essentially that if it's an omission, then, and there's no duty to act, and it's in the best interests of the patient, then there is no obligation to act. So where it's not an obligation but an omission under Bland, you could end treatment even though you know that it's going to lead to the death of the patient. And Lord Joffe said at the time, this is the crossing of the Rubicon moment, and I think he had no idea of just how bad it would get. Aintree University Hospitals is the next one, and that significantly progressed the jurisprudence on this, and it was Lady Hale writing for the Supreme Court, and again, with folks with my accent, she's really the Justice Ginsburg of the UK. So highly prized legal mind who always came to the wrong judgment on our issues. So on abortion, on assisted suicide. So she was actually, in that 5-4 Nicklinson judgment, she was one of the 4 dissenting. And here she wrote for the court, finding that the individual, Mr. James, who was age 68 at the time of events, his treating hospital said there's no chance of recovery, and they went to the Court of Protection to essentially end his life. And they took the Bland case even further. So this is where they said, look, the Mental Capacity Act, which determines mental capacity to make decisions about medical care, the courts can now step into the shoes of the individual and act in his best interest. But they don't have to decide in a way that the individual might decide. So they're saying, and then they said, that even if the individual at an earlier stage of life said, I would want life-sustaining treatment, that could be disregarded by the courts. Because they could step into his shoes and say, well, he didn't think about what it would be like in this situation. And essentially what they came up was with, look, if we decide, if the medical team decides it's not worth living, and there's no meaningful prospect of recovery, then we can end the life. And that was deemed to be good practice, best practice by Lady Hale. And I think what is most shocking about that is being able to override the intention of the patient. Now jumping ahead to the bill. Now we are in 2024, and we have the eligibility criteria for Leadbeater's bill. So you must be mentally competent, and they define competency by the Mental Capacity Act. Must be resident in England or Wales for at least 12 months before the request. Must have a terminal illness. I'll define that in a slide in a few minutes. And must be over the age of 18. Now, interestingly, you can be under the age of 18 when a doctor brings it into the conversation. So it's almost like, for those familiar with the Gender Recognition Act, you can only get a gender recognition certificate as a transgendered, someone who identifies as transgendered, if you're 18, but you can start the process before you're 18. So essentially that's what this is. The coordinating doctor. So when you go into the doctor's office, he first has to confirm eligibility, that you have a terminal illness, that you have a prognosis of 6 months or less to live, that you are resident in England or Wales for at least 12 months, and that you have a doctor essentially in England and Wales. They verify your identity, and they have to witness the signing of the first declaration, and then they have to refer it on to an independent doctor. Now, there's no compulsion per se, and I'll get into that a little bit, for that doctor to have that conversation. So if it's introduced by the patient, the doctor doesn't have to do the consultation. He's not required, and I'll get into this a little bit, he's not required to refer them on anymore, but he does have to signpost them where they can get the information. And there is also the prospect of doctor shopping. It doesn't have to be your GP. You can go to any GP and have this conversation. I think the interesting thing about this is the doctor can introduce it into the conversation at any time on his own volition. And so there's a concern of unintended coercion. Late at the end of the presentation, I'll be talking about Canada and what's going on there, but it's not just Canada, it's Netherlands, Belgium, where we see people dying because they feel like a burden, where they struggle with things like credit card debt. So they might have physical symptoms that make them eligible, but it's other things in their lives that are leading them down that path. Yeah. So then there's the second medical assessment, which requires beforehand a 7-day reflection period. The independent doctor then will essentially do the same assessment that the coordinating doctor will do, looking for eligibility, looking for whether the person has informed notion of what they are really intending to do. And he, like the coordinating doctor, has the right to reject them. If he rejects them, they have a right to go to yet one more independent doctor, and that ends the process if they're rejected twice. However, it kind of doesn't. It slows the process down, but like I said, they can go to as many coordinating doctors as they want. So once they get the second rejection, all they have to do is go to another coordinating doctor. There's no waiting time, and they can just keep on doing it. I think what's more scary about it is, and again, I'll talk about this a little later in a Belgian case, is that there are doctors who are essentially rubber stamping this, and not just rubber stamping it, but are zealous in their desire to end people's lives, and they work with others. And so there certainly will be a network of well-known coordinating doctors and so-called independent doctors who will be willing to rubber stamp. If confirmed, the individual may petition the assisted suicide panel. The bill defines terminal illness as someone who is terminally ill is a person having an inevitably progressive illness, disease, or medical condition. So it was medical condition. That's been scrapped as of last week in the amendment. So now it's just a disease or illness which cannot be reversed by treatment. There has to be a reason that it also has to be that the person is reasonably expected to die within 6 months of their diagnosis. So there's no requirement to consult an expert in the field of the prognosis, which is interesting. So a GP with no experience in motor neuron disease, for example, or progressive multiple sclerosis or cancer, can send you to the independent doctor who likewise, with no experience, can give you that prognosis of 6 months. So that's quite remarkable. In itself, there's a balance of probabilities threshold, so it's not beyond a reasonable doubt that the person will die within that 6 months, or that they haven't been coerced, and that they have the mental competency to go forward. There's no requirement, even if either doctor suspects that the person suffers from depression or lacks mental competency, to have them see a psychiatrist. So there's some serious safeguards missing in how this is all done. And remarkably, with this definition, it can include diabetes, hypothetically, even though that's treatable, it's not reversible. It could include anorexia. And in committee, no less than 5 amendments on anorexia were tabled, and they were backed by eating disorder charities, and all 5 were rejected. So it tells you, when they have this public-facing message that, no, this is not what the bill is about, while they are rejecting the key amendments on these procedural safeguards. On prognosis, it is incredibly difficult to say that someone is going to live 6 months or less. So when the Liverpool Pathway had its review, the government said, bluntly, that diagnosing imminent death is a far more imprecise science than people realize. And again, I would point you to the Noel Conway case, where that 6 months ended up being 7 years, and it could have been significantly more than that. I have the Alfie Evans slide here. So it was really Charlie Gard, the case before him, that set the precedent. So that Aintree case I was talking about, where it was the right to step into the shoes of the patient and say they wouldn't want to live in that situation. That somehow became, not only will we stop treatment, but we will force you not to get treatment elsewhere. And that was a seismic jump, I would say, because in both the Gard case and the Alfie Evans case, I speak more to this case because it's one that I was involved in, and we at Christian Legal Center were involved in. It was a horrible case, but the Vatican Hospital Bambino Gesù was willing to take him on without any taxpayer funding from the UK. The NHS wouldn't have to pay a pound for it. There was a Polish air ambulance that was willing to take him free of charge. It was all set up, and when he ended up passing away, they had a police escort around the hospital to make sure that no one would try to get him oxygen to keep him alive. And I think what's fascinating about this case is, so you see the family there, and Tom Evans, he was a young man when he had Alfie, and he was a young man when these events happened. And he, at first instance, was his own lawyer in defending the case. So you had the trust, who had Queen's Counsel, it was Queen's Counsel at the time, loaded up with Queen's Counsel, paid for by the taxpayer dollar. They had all their experts in line before they ever brought this case to the Court of Protection, and you had Tom Evans having to cross-examine these experts. And as you can imagine, the judgment wasn't particularly kind. I mean, he's very kind in saying what a nice man he was and how caring he was, but on the facts, it was stone cold. And what came out of that, and people without a legal background don't realize. They think, okay, well, the Supreme Court, that's where the action happens. It's the court of first instance where those facts are set in stone. And once they are set in stone, it's almost impossible to overturn. And that's the facts that went up on appeal. And I'll just read some of these things that came from the court. Professor Cross, at paragraph 16 of the Court of Protection's initial judgment, it is unlikely that Alfie can breathe without assistance. Professor Haas, at paragraph 21, Alfie's inability to breathe is a consequence of the disease and not likely from the medication administered. Dr. M, at paragraph 25, he is completely dependent on mechanical ventilation to preserve his life. Professor Haas, again, at paragraph 43, withdrawing treatment will immediately lead to his death. Dr. R, who is the primary medical expert from Alder Hey, the treating hospital, Alfie is 100% dependent on ventilator support. And finally, Justice Hayden, who delivered the judgment, said, it is the ventilator that has been keeping him alive for many months. He is unable to sustain his own respiratory effort. So the thought was, the moment, they gave him minutes, I remember because I was in the courtroom for that, they gave him minutes to live. Can anyone guess how many days he lived? Five days. And that, together with sedatives that he was taking, together with dehydration, together with not being fed or minimal feeding, led to his death. So who knows if he had still been getting nutrition and water, how long he would have survived off ventilation. And his lungs were very compromised, having been on ventilation for the period he was. So again, prognosis, not always reliable. Initially, when this bill was being cobbled together, the idea was after your independent doctor gives a sign-off, you go to the High Court, and the High Court can question the coordinating doctor or the independent doctor. So if it was approved by the High Court, there was a 14-day reflection period, and then the coordinating doctor reassesses eligibility before prescribing the life-ending substance. What happened was the high courts came out and said, are you insane? Like, we were looking at other jurisdictions where this has happened, hundreds of applications straight out the gate. We don't have the time for this. I mean, we have cases at Christian Concern where the waiting is 2 years for a hearing. So very impractical. That led to some embarrassment. And what happened was essentially death panels were the answer. And they've kind of dressed that up in a way, saying this is the best safeguard we can have. It's got a high court judge who will be presiding as the commissioner. So the commissioner will be either a high court judge, a court of appeal judge, or a Supreme Court judge, past or present. But they aren't part of the day-to-day. It is a lay panel that hears evidence. Now, Section 15 of the amended bill talks about it. They essentially have the same procedure as the High Court in that they must speak to either the coordinating doctor or the independent doctor. They must speak to the individual seeking assisted suicide, but there is an opt-out of that for what they deem as exceptional circumstances where they don't have to speak with him. Usually when I hear the term exceptional circumstances, when it's not defined, that becomes normal circumstances. And again, it's a multidisciplinary team. Now, it's not a high court, and so a lot of those procedural safeguards guarding the integrity of the procedure are not there. And the fact that it's a panel dedicated to this activity, to death, kind of gives you the direction of where those cases are heading. So there's been a delayed rollout that's made the news. Now they're saying instead of 2 years, it's probably 4 years before this, if passed, will take action. And there'll be a federal election in 2029. So there are questions of well, this will certainly become an issue in the election, should it pass, and whether it'll continue on afterwards is another question. We have the distortion of dignity. So really there are competing definitions of dignity in the world. You know, as Christians, we take our dignity by being created in the image of God. And I was thinking, like, beyond Genesis, what does the Bible say about assisted suicide? And I was thinking, well, okay, Christ tells us we have to carry our cross, which means carry our burdens, including our physical burdens. And I thought, well, you know, Christ, when he was on the cross, was offered sour wine and gall, which would have quickened his death, and he didn't take it, which is, I think, a quite powerful statement. And I thought, well, okay, in the Old Testament, there were at least two people. There was Saul, and we were discussing, we couldn't figure out the next one. We first thought it was Joab or Abner. It could have been another king. But there was two instances where there was people injured, Saul being one of them, in combat, who were then asking their person who was with them to kill them. So certainly with Saul, we know that he wasn't considered a righteous king under his first Kings. And in the second instance, it was also something that was condemned. So there, you know, even though there was some people being helped to die in the Old Testament, they were always condemned. It was never seen as a positive action. But nevertheless, I think the medical royal colleges taking a neutral position, and that's a new thing, because for a significant period of time, the colleges have all been opposed to assisted suicide. And what's interesting is the colleges themselves have now taken a neutral stance, not their members, because the surveys are what the surveys are. The members still don't want any part of this. So it's been this cultural shift. And I've got Jeremy Bentham here, because Bentham had this philosophic calculus, which was like avoid pain and seek pleasure. And that has become the kind of the marching band that keeps this culture going. There's another philosopher from Vienna, Viktor Frankl, who developed something called logotherapy. He was in the concentration camps, lost literally every member of his family, a powerful writer and a powerful therapy. But he talks about the crisis of meaning. And it's remarkable that now that we have kind of this luxury of time that we didn't have in previous generations, and we have social media and everything making it, there's a line from a song that I like, that we live in a diamond mine, but we can't touch the diamonds. And just everyone is depressed. We have this crisis of depression and crisis of meaning. And that kind of drives this type of thing where it says, well, it's no longer dignified to live because of my depression. It's no longer dignified to live because of my condition. And that's troubling. Just as a Christian, it says we are not doing our job in giving people a choice of meaning, a reason to live. And, you know, this is not an easy issue. Assisted suicide is not an easy issue because you have people who are suffering, because you have people who have lost meaning, because you have people who don't want to live because no one's visiting them or calling them and they feel like a burden. And just from a Christian perspective, I would encourage you that if you have people like that in your life, reach out and try to make their lives a little better. Because surveys have said the vast majority of people, if they had better support in their lives, if they were shown more love and care, would want to continue on, because we all want to fight. We all want to fight. It's in our nature. So the procedure, the individual themselves has to inject, once you've gone through all the steps, the individual themselves has to self-administer the prescribed substance. Interestingly, there is no definition of what that substance will be. That's up to the Secretary of State. There is no universally accepted substance for this procedure. And so that, again, is a safeguarding issue. And where individuals can't self-administer, then obviously the doctor has to assist, and no one's going to be there filming them in the room when it's happening. So no one really knows what happens behind closed doors. The coordinating doctor must be present, but he doesn't have to be in the room. He can delegate it to someone else to do. And the final declaration has to be recorded. So the person is given a final opportunity to change their mind. But again, when you're so far down that train, it's just hard to get off. Even if you want to, you feel like you put everyone through this. And so it's just one of those things. And I've put a quote from John Paul II here. And I was thinking of like evangelicals I could quote. But the reason I like John Paul II, and I can see that there are other people with gray hair in this room who remember him and how he lived his last years. He suffered. He suffered horribly, but he did it with such dignity. And I think he was an inspiration for how to live and suffer with dignity. So again, there's a worldview bias, and I won't go into these cases very much, other than to say that these were again supported by Christian Legal Center. Sadiksha was a 19-year-old. She was again on a different category because she could speak. She was fighting. I mean, what is quoted over and over again. She was going to die trying to live. And in her case, you had two consulting psychiatrists, both saying that she was mentally competent. And then you had the medical team, who weren't psychiatrists, who said, no, she doesn't have competency to make her decisions because she's not agreeing with what we want to say. She wanted to go to Canada and get experimental treatment and live. And they overrode her wishes and ended her life. That was an absolute tragedy. Just last year, the case was revisited by the Court of Appeal on the question of mental capacity, and it was quite a stunning judgment to see how they, too late, so in a sense meaningless.
She died by
Was it? Yeah. Yeah. And they said that she was in every right, she had every right to want to keep on fighting, and that she was mentally competent. So they overrode that decision of the earlier court. And Archie Battersby, that's another case. So Archie was another one who kind of stole the hearts and minds of the UK for a while. And I mean, it's still the question of how we ended up there, whether it was some people said it was a TikTok challenge gone wrong. Others said it was something where he just accidentally strangled himself. What people don't talk about is kind of the underlying nature of the substance of that case. And so they were saying, the hospital was saying, the Whitechapel Hospital was saying that his brainstem no longer functions, so that he was legally dead, and they wanted to do a test, a brainstem test, which if he failed, they would remove life-sustaining care. The family was saying it's way too soon. Brain injuries are notorious for long convalescence. His mother, Holly Dancer, was saying that, like, I could feel him squeezing my hand, and clearly if he had no brainstem, that wouldn't be the case. And with all these other cases, the hospital went through, it got rubber stamped. Test was done, he failed, he was removed from life-sustaining treatment and passed away. So it was just this trajectory, this culture of death that we're seeing. So the courts have almost universally ruled and sided with the hospitals or the families. I mention this, I know we're on the assisted suicide, but I mention this because they're tracks on the same train. Going back to the bill now, you have the right to cancel at any point up until really the substance is injected, there's no obligation to perceive, but again, once you're going down that track, it's very difficult. Briefly to close out, I'll talk about some of the international concerns. So there's been other jurisdictions, obviously, who have passed assisted suicide laws. New South Wales is one of the more recent ones in Australia. It is up there because it is very similar to the one being proposed here, in that there's a 6-month prognosis. Within the first 3 months, you see there was 517 people requested. So imagine if the High Court was doing this and got that kind of volume of applications. 130 people completed the process. And you'll see in your packets you've got papers on Oregon, and Oregon is always held up as the best practice. And it's a fascinating packet in the sense that it shows quite a few things. One of them is kind of the gap between the people who have applied and the people who have followed through, which is interesting. Oregon also talks about the reasons people died, so it's kind of shocking to see how many people had depression or felt like they didn't have worth. Two of the most shocking things you'll find in there is the number of people who took the prescribed life-ending substance and survived. I think it was something like 6 or 10%. It was not a nominal amount, and the number of people who outlived their 6-month prognosis. So the New South Wales law here is there just to give you a sense of how quickly this progresses. That's just one part of Australia, one of the provinces. So to have it here in England, it just gives you an idea of scale. Belgium, previous to my time here, I did a lot of work, to my time here at Christian Legal Center, I did a lot of work in Belgium, especially when they were passing the child assisted dying, assisted suicide bill there, where kids who can't drive, can't drink, can't do anything, essentially, but they can choose to die. And I went there, and it was depressing because the Speaker of the House, which is actually a sizable position, as you know, was opposed, but wouldn't speak up. No one would speak up because they said it's a cultural issue. We can't speak up. And but he did introduce me to a gentleman named Tom Mortier. Tom, his mother died of lethal injection. And when I met Tom, he was still going through the trauma of that loss because no one told him. So like this bill here, where there's the consultant, no one at no point, not the commission, not the doctors involved, they don't have to tell the family that this is happening. So same thing applied in Belgium. So we have Mrs. Mortier, who had suffered from depression, who just broke up with her long-term partner, and on that basis wanted to end her life. Went to her psychiatrist seeking for the okay for assisted dying. He said no. I mean, you have a meaningful chance of recovering. She went to several others. They said, sorry, but you don't meet the criteria. She finally went to a gentleman who the court anonymized as Dr. D, Dr. Death. I mean, he's a strange man. He actually gives tours of Auschwitz for some reason to give you perspectives of life and death. But he was more than happy to sign off after she gave a €2,500 donation to his end of life association. And he also sat on the commission that okayed the procedure and found someone else to do the sign off. And she got lethal injection and passed away, and Tom found out only afterwards. So this was the first time that the European Court of Human Rights on this issue engaged Article 2 and found a violation, saying there was not enough safeguards in Belgium to prevent this type of thing happening. Canada, and that's where my accent is from. The gentleman there at the bottom, not beloved particularly, especially not by anyone, not his own party, not anyone. But MAID has been a nightmare. And there was a parliamentary inquiry into it in October 2024 where essentially the people involved said the safeguards are completely impotent, and it's just run wild. And people with credit card debt, poor housing, difficulty in obtaining medical care, and with an elderly mother still living in Canada, I can say the medical care is not particularly quick or good. And so you have people wanting, to end their lives because of these things. So while they might have conditions which make them eligible, that's not the reason they're wanting to end their lives. And there's, several scandals from Veterans Canada where people, calling in on the helpline seeking things like treatment for PTSD, a wheelchair ramp, where they were asked whether they wanted to end their lives, and they were just utterly shocked. And that's kind of how far these laws can go. Switzerland, so between 2000 and 2014, researchers discovered that the crude rate of assisted suicide in Switzerland more than tripled during the study period. The vast majority of those who ended their lives were older, had no children, and no religious affiliation. So precisely, people who hadn't experienced human flourishing. They hadn't lived their lives in the most meaningful way possible, and that was basically the cohort who would end up going for assisted suicide. Netherlands, again, their instances of euthanasia doubled. 19.8% of cases falsely recorded. You also have a packet, a Times article that was written very recently that's in your packet on what's happening in the Netherlands. They had 10,000 deaths from assisted suicide last year. That was that's 5% of the total amount of deaths in the Netherlands was assisted suicide. You have 20 newborn infants euthanized every year in the Netherlands. People for depression, people for any number of things. So this, again, there are no jurisdictions who have done this right. And the bill that we have before Parliament now, they say is full of safeguards, but Labour is already saying we need more. This isn't enough. And it's been our experience at Christian Concern with things like same-sex marriage. So before same-sex marriage, there was cohabitation. There was other forms that were legalized as hitching posts, knowing that once we get this in the door, it'll end on the other side, and that's exactly what is going to happen. As well-meaning as Ms. Leadbeater would lead us to believe she is, this is the end game, whether she wants it to be or not. So conscientious objection, Article 9 of the European Convention of Human Rights protects that specifically. So the bill, again, has been changed from last week, but it had been that Christian hospices or individual doctors, if they refused to consult, had to signpost to someone who they knew would. So that's been watered down to signposting to information where they can, but that still is participation. So there are compatibility issues with the Human Rights Act, with that provision and several others. Definition of medical practitioner. Anyone who reads the bill will see the word medical practitioner everywhere. So you assume doctor. Well, probably, but the Secretary of State is the arbiter of how to define who has the relevant experience to be a medical practitioner. So it really does open the door. And I would cite the Abortion Act as something where you can see kind of the Secretary of State going off the rails with their discretion, where you had a pretty tight act for quite a long time until COVID, when they decided that the home was going to now be a place where you can obtain an abortion. So it used to be hospital, clinic, places that were closely regulated. And so you saw that was the purpose of the Abortion Act, Section 1 of the Abortion Act. It was to make it somehow safe, but they gave this discretion to the Secretary of State, who said now you can do it at home. And that became primary law after it was eventually passed. So when we see things like medical practitioner written in the bill, don't be assured that that means doctor with relevant experience. Proxy signing, this is one that's changed as well. It had been in the earlier iteration of the bill that it could be someone who's known the individual for a period of, 2 years, or someone of good standing in the community. That's been changed now to, the first part still stands, but it's to someone who will be defined later by the Secretary of State. So that's a way of passing the buck. It doesn't mean it'll be better. It means they don't want that voted on because it's too controversial right now. Mental capacity, again, there are far more stringent safeguards you can use than the legislation they're using, the Mental Capacity Act. There's no test for, I think the amendments now says that the Secretary of State does have to do some kind of guidance on looking out for coercion. But if you, I mean, again, with the example of abortion, you know, to obtain an abortion under the Act, you need 2 doctors signing off. It's now common practice that second form is pre-signed. So these safeguards essentially are meaningless when it comes to coercion. You could have a doctor who's just intent on, you know, and they might believe that they're the knight in shining armor ending these people's lives, but they're not. I mean, they are pushing this issue, you know, through the consultations and otherwise. And at the very least, there is a risk of unconscious bias. I mean, so that's it. It's been a long journey to get to 2024, 2025. It's been one of the most coordinated efforts we've seen in getting something to this point. But we do have a chance to stop it. Our chances with the euthanasia that's happening through the courts, we lawyers will keep on fighting that to make sure that is done better, that there are safeguards put there. But we do have a legitimate chance looking at the other jurisdictions where how badly this is being done. Look at how this is being played out, where we're being told that lessening the safeguards, like the commission rather than the high court, is somehow a greater safeguard. So, I mean, write your MPs because the time is limited. If you are in the profession, use your skills to lobby, campaign, otherwise, because we gotta kill the bill. Yeah.